If the judge is not satisfied with the decision, can he make any changes?
Yeah, if the jury comes back with a not guilty, the judge cannot do anything. The case is over, kaput. If the jury comes back with a guilty verdict and the judge feels that a manifest injustice has occurred, the judge does have some remedies where the judge can set aside the judgment if he feels that, that there's been error in the case and that a manifest injustice has occurred. That is typically not done very often. However, there was a case within the last 10 years, a rape case where two male students were charged with date rape of a young lady. And I don't know all the facts. I wasn't the judge. I just kind of wrote about it in the newspaper, but it happened here in Fulton County. And these two guys were convicted of rape. And the judge felt like the verdict was not justified by the evidence that was produced at trial. And she did set aside those two rape convictions. And the case was tried over, and I think it eventually pled out to a lesser offense.
The important thing to remember is if the person is found not guilty, there's nothing the judge can do. Okay? So that's one of the important things in our system. If they're acquitted, there's nothing the state can do. They can't go and arrest him again on the same charges. They can't try him again on the same charges. If he's found not guilty, that's it. It's over. It's finished.
So
he goes out the courthouse.
So they are the judge.
They're the judge, yeah.
The jury.
No, once they are found not guilty of that charge, even if new evidence comes up, they can't be tried on that charge again.
They can be charged on other.
If they commit some other offense, yes, then they can be charged of something else.
And also, if they're found guilty and new evidence comes up, which tends to exonerate them or indicate that they shouldn't have been found guilty, in that case, they can sometimes get a new trial.
What if it's make worse,
If it's worse, it doesn't help. I mean, once you're found not guilty, that's it. Case over.
And the classical example would be a famous trial by the name of Simpson, was tried in Los Angeles. It's over, it's innocent, right? But they got him on a different case in Denver. So that's a whole deal, a different deal. Yeah.
Las Vegas.
Las Vegas.
I mean Las Vegas.
Yeah. Anybody have any other questions?
Any kind of a question.
Are there any possibility like a juries recognize him, like maybe we're friends or something?
Okay.
What is the question?
That's a good question, and one of the first questions that the attorneys asked the jury panel out there is, does anybody know the judge? Does anybody know me? Does anybody know the defendant sitting over here? And so if anybody does know any of the parties in the courtroom, they're asked to identify that so the attorneys can make a decision whether or not that person can be fair. Because you might have a situation where a prospective juror may have taught the defendant in 5th grade and recognized him, say, well, I taught him in 5th grade, but that juror might not have had any contact with him in the last 10 years and could still be fair and impartial. But if the juror's little sister dated the guy, might not be able to be fair and impartial. So those kind of questions are asked, and sometimes jurors are asked to be struck because they can't be fair by the judge. And if the judge determines that they can be fair and that they are not eligible to be struck by me, the attorneys can still strike 9 jurors each. The state and the defense have the ability to preemptively strike 9 people. And so you start out with 30 people who are qualified jurors, and they strike 9, and the defense strikes 9, and then the 12 jurors remaining from the 30, after you strike 18, that's the jury.
So you have no relationship with me, no relationship with them, so you coming in a fresh idea. You hear the case, and the judge instructing you to judge my case on what you hear. but they don't want alternative, ulterior motives. If you are my brother, you cannot be a juror, because you're going to make me innocent. Huh?
All right, any other questions? Huh? Any questions of the
Any
students?
kind.
Any questions of students? Everybody here undergraduate, right? They're getting an undergraduate degree. So you see that in law school, you can major, the thing about law school, you can major in anything undergraduate, okay? You can be in architecture, you can be in music. It doesn't matter in law school, just as long as you have the grades and do well on the LSAT, and you can get in law school. That's different than medical school. Obviously, in medical school, you have to have a lot of science courses, biology, chemistry, those kind of things are required to even apply. But in law school, you can major in anything. I was a political science major. What were you, Jesse?
Engineering.
Engineering. See, here's an engineer, and he's going to law school.
Business, finance.
Business, finance,
Marketing.
marketing. So you have all different kinds of degrees. I was political science.
Criminology.
Criminology. So that's the thing about law school, is you're not, in undergraduate, you don't have to major in law. Like in England, you start off in college, you do pre-law. So that's why it takes 7 years to become a lawyer.
I want to ask you a question on the basis of little synopsis, the argument and the argument. Suppose you are the jury, what do you think? Did I do it or not do it? And her statement was, if there any reasonable doubt.
We really need more evidence.
There you go, see? There you go. Now that's the thinking juror right there. We need more evidence, right? We can't make a decision on that. He wants you to find him not guilty. But there's too much evidence on him right now. All right, anybody have any other questions? All right, we're going to take some pictures with the judge.